Okay, wonderful. Um, okay, so we are just going to begin with a quick overview and framework of sources of immigration authority. Again, you all might have slightly different experience and interaction with the law, but we just want to give sort of a scaled out look at where some of these laws and policies come from. So first, we have um, immigration law. So that, as we know, is like very slow to change. It was last updated with the illegal immigrant responsibility Reform Act. I think I forgot like an I in there. I'm sorry. And all of immigration law is codified in the INA. Judge-made law or case law is also a source of immigration authority. So for certain things like visa categories, those are, fixed and encoded in law. But also as a source of immigration authority are regulations, policy, and other executive branch made law. So you might notice there's certain policies that seem to change with like every administration or change much more rapidly. So things like the countries designated for TPS or the number of refugee admissions every year. Those all fall under sort of executive immigration authority and are more apt to change. We also have a quick overview of the different immigration agencies you might be encountering in your work. So as you can see, Afghan applicants, they are probably going to be interacting with all three of these different departments. And one of the main things to know is that even if you're working on the same type of case claim or, with a client who's interacting with the State Department, as well as USCIS, and as well as maybe an immigration judge, these departments do not necessarily talk to each other, particularly when it's to share information that might be able to help your client. But of course, in typical US fashion, if there's something that might harm your client, the agencies will in fact talk to each other. So that's just something to be aware of, that when you're interacting with an agency that might be in one of these different departments, you should treat that as sort of, needing to update that person with your client's case fresh. And so just some of the important ones to highlight: USCIS is where you will probably be, directing someone to apply for different immigration statuses. CARE in the State Department is responsible for a lot of the Afghan evacuation efforts, and the Department of Justice covers any sort of immigration proceedings, as well as, removal proceedings. And next, we just kind of wanted to highlight some common immigration documents that your clients might be coming to you with. We're going to talk a little bit more about these throughout the presentation, but basically with some of these different documents, they have a lot of helpful information that can help you find even additional information about your client and where they are in like the immigration process. So the ones that we've highlighted here are, an employment authorization card, if someone has been able to get that. We also have two examples of the Form I-94, which is an arrival record that someone might get when they, cross the border from Customs and Border Patrol. And then someone who, might have crossed the border without status could be issued a notice to appear. And so what I've done is I've highlighted in red the places you can find somebody's A number or, USCIS number. That'll be really important for figuring out things like if your client is in removal proceedings, which we'll talk about later. And then highlighted in yellow are the places where the US denotes what status they believe your client has. So that can be their, immigrant status or non-immigrant status, which you might find on the employment authorization card. On the NTA, that would probably be the unlawful status that they're charging your client with, like entry without inspection. But what we're going to spend kind of the first third of this presentation talking about is different pathways to immigration, and we want to just provide you all with an overview of some of the different avenues. That way, if you have a client who is looking to stay here permanently, and wants to know what their options are, hopefully you have like a sense of a framework to direct them either to an attorney or to, the right set of processes. And also, just as a quick reminder, immigration, that is a path to permanent residence, that's a path to a green card. We'll also be talking about a lot of different non-immigrant statuses, and temporary statuses. So those are just ways to stay in the US lawfully for a shorter period of time. And it's possible to be on one of those while you're pursuing one of these 4 main paths to immigration. So the 4 here are employment, family, humanitarian relief, and the diversity lottery. We're not really going to get into employment or the diversity lottery. If your client's able to get a job that offers them work authorization, that's great. That'll probably be a separate process. We'll mostly be talking about humanitarian relief, as that is most likely what Afghan clients will be pursuing. But we also wanted to quickly talk about family reunification, because if you have a client who wants to stay here lawfully, one of the first questions you should be asking is if they have a relationship to a US citizen or long-term an LPR. So as an overview for the family-based immigration pathways, we're not going to get into the distinctions between all of these different tiers, but one of the main takeaways is that there are sort of 2 categories of family-based immigration pathways. The first is the immediate relative pathway. So if somebody is the spouse of a citizen, an unmarried child under the age of 21 of a citizen, or the parent of a citizen who is over 21, they're immediately able to come. There is no limit to this sort of visa pathway. On the other hand, there's a separate set of family-based preferences. So if somebody has one of these relationships, they're able to apply for a visa based on one of these categories. These are capped every year, which means that there's often a very large backlog, and you must wait for what's called a priority date. So each category has a date after which the USCIS will begin to consider the application. So if one of these preferences, the priority date isn't until 2026, unfortunately, that application will not be considered until then. So the main takeaway for you all here is that the US has kind of created a hierarchy of family relationships, which might not represent, the way that culture or that family prioritizes their relationships. And unless someone falls into that top category, they should be prepared to probably wait for years, unfortunately, and will need to pursue a temporary status in the meantime. The majority of our presentation is going to cover humanitarian relief. So this can be divided into immigrant and non-immigrant categories. In the immigrant category, we have refugee and asylee status. We're mostly going to talk about asylum here, as well as special immigrant juvenile status, which we're not really going to get into, but basically if someone is under 21, single, and cannot reunify with their family because of abuse or neglect, they can adjust to this status. And then under non-immigrant status, we have, humanitarian parole, temporary protected status, Convention Against Torture relief, withholding of removal, and TNU visas, which are actually a little bit separate because if somebody, is a victim of a certain crime and cooperates with the police, they can get one of these visas, which actually can, in fact, lead to a green card. So in some ways, it looks more like an immigrant visa. And on this next slide, I have this chart that just sort of outlines the different requirements for each status, as well as what's probably going to be the main questions somebody might have, when you present them with their options, which is basically, can my family come? Can I work on this status? And, will I get a green card? And am I able to travel? So we have this slide here for your reference. We're going to refer back to different parts of it throughout the presentation. But a couple things to note here is that for all of these statuses, someone is able to work. So if they're here lawfully, they can pursue a path to work authorization. And then where I've said maybe, we're actually going to get into that a little bit later in this presentation. We'll kind of go through each of these categories in the final third of the presentation. But particularly for travel, I say maybe because people on these statuses must actually apply for advanced parole, which is different from humanitarian parole or OAW. That just basically means advanced travel authorization to get the ability to leave and re-enter the United States. So now I'm going to kind of break down some of these different statuses, sort of in the way that I would approach interacting with an Afghan client for the first time. So kind of going a checklist of seeing which statuses they might qualify for, or to see if they have them already. So the first one that we're going to talk about is temporary protected status. So if someone is an Afghan national and they have been living here since September 20th, 2023, they are now able to get temporary protected status. And so what temporary protected status is the US creates a list of countries where it's determined that there's a humanitarian crisis or war or some other situation where if people from that country come to the United States, the US will not deport them or remove them because they've recognized that the conditions are unsafe. So recently, on September 20th, Afghanistan was redesignated as one of those countries. So what that means is that people who were on temporary protected status before, for the 2-year period prior, they're able to renew and get an additional 2 years of temporary lawful status in the US. But because it was redesignated, Afghan nationals who were not eligible for that first round of TPS might now become newly eligible to register if they meet these 2 requirements. So I know that November 21st, 2023 is in the future, but they can actually start applying right away. They just can't, leave the country after that date. And, these are the basic requirements. There's more information online about evidence, you might need to support this, as well as certain bars. But this status is not even necessarily like applying, it's more like registering. So it's something that, you're definitely capable of like assisting a client with, or they can do it themselves or with a translator. So this is always a good first resource. And, of course, this is very limited protection. It only lasts 2 years. They cannot bring family. They cannot travel without that sort of advanced authorization I talked about, but it means that they cannot be removed or detained, solely because of their status. They might be removable for, another type of offense, but this gives them lawful status. And people can get work authorization with TPS. And now I also wanted to mention humanitarian and OAW parole. You probably wouldn't be assisting anybody with applying for parole because it is something that someone applies for outside of the United States, but you might be working with people who have either humanitarian parole, OAW parole, or, you might hear it referred to as Form I-131. So just kind of give a quick sort of distinction. Operation Allies Welcome is in its second phase, which means that now anybody sort of going through that program, any Afghan national who's still in Afghanistan, is going to be directed through one of the permanent immigration processes, like, the refugee admissions process. But if someone was paroled through Operation Allies Welcome, that means they probably got parole between August 2021 and October 2022 in that sort of first phase. So that's not really an option for people now. However, humanitarian parole is always an option. And this is sort of a discretionary decision made by USCIS and the US Embassy that the person's applying from, where somebody needs to show that there's such a urgent humanitarian need, or other sort of circumstance that is too urgent to go through the traditional admissions process. And they get this sort of temporary authorization to come to the United States. The USCIS determines the length of that authorization, so it might change from person to person. And kind of the only benefit of parole, aside from lawful status, is that you can also get work authorization. However, if someone is an OAW parolee, they are also eligible for this DS 4317 family reunification process. So we'll talk about that on a later slide. But I just kind of wanted to highlight that because somebody can be on TPS and also want to maintain their parole status. So these are two statuses someone can hold at the same time. And it's important to make sure that people are maintaining their parole if they're eligible, to stay eligible for those types of benefits like family reunification, even if they do have another status like TPS. And so sort of the last kind of special thing to flag when you're working with an Afghan client is the special immigrant visa, or the SIV option. So these are available for people who worked, or Afghans who worked for and on behalf of the US government in Afghanistan. So that there's kind of two categories here. There are translators and interpreters who worked for the military, or people who worked for the US government, one of its contractors, and the ISAF, and are now facing threats because of that work. Getting one of these visas is a very lengthy process. It has a couple extra steps, including the sort of military approval stage. This application must be done either at a US embassy, or if you're already within the United States. And it kind of raises, because since it is a very long process, you might encounter people who are at some stage of this process and need temporary status in the meantime. But also if you're working with someone and you hear that they might have done some work for US government or US government affiliate, a little light bulb should go off in your head to maybe see if they've considered this option. But now we're getting into the kind of middle third of our presentation, where we're going to talk all about asylum. And so just kind of at the outset, I kind of wanted to break down this distinction between a refugee and asylee, because they refer to almost an identical set of protections in the United States, with the real distinction being where somebody applies. So an asylee is considered a refugee that has already entered the United States. And this is important because refugee protections are actually founded in international law. So there's sort of this higher mandate of the United States to issue these sets of protections. One of the most major protections is the principle of non-refoulement, which means that a person cannot be returned to a country that is persecuting them. And that's an important thing to keep in mind, because that sort of underpins some of the other lesser and more temporary protections as well. So just kind of wanted to make that distinction here. Also, two other important distinctions are that there is no limit on the number of asylees the US can take, other than its own bureaucracy. Whereas refugees is a yearly number determined by the president. However, in recent years, the US has not come anywhere close to hitting its cap. I think it's about 125,000 refugees this year, and the US is only on track to admit about 60,000. But that does change per administration. And then one of the other key differences is that refugees must adjust to LPR status after being in the US for 1 year, whereas asylees cannot adjust to LPR status before 1 year, and they may adjust after 1 year. So for them, they have more of an option there. So I want to quickly overview the requirements for asylum. Again, you might not necessarily be helping somebody with their application or with their asylum case. But I wanted to flag what is required of asylum because it can also be very helpful if you have a client who's interested in applying, to start talking through maybe the types of evidence that they'll need to get, or sort of the things they need to be thinking of as they begin that process. So asylum has three main requirements. There must be persecution, because of, it's kind of called the nexus requirement, one of these five protected grounds. So for persecution, this must be a well-founded fear of persecution, or it must be some sort of severe past persecution. And this persecution must be done by the government or a group that the government is, sort of implicitly condoning and is not controlling. So this doesn't cover sort of any sort of harm that we might consider offensive, and it doesn't, protect against harms that are done by private actors. There must be government involvement, and it must hit this high standard of persecution. And a person can't be able to mitigate this by, like internally relocating or somehow just like moving or changing behavior. And one of the other things to note is that this fear must be subjective and objective. So these are just kind of two legal standards, where basically any ordinary person in the same situation must also have, it would be reasonable for them to fear persecution. And also the client must have, personally felt that fear. So if a client maybe took a long time to leave the country or something like that, there's still ways to show that they did have fear, such as they were using that time to get money or arrange their travel plans or coordinate family safety. But that's just something to keep in mind. And then I'm going to talk about these five protected grounds on the next slide. But I also want to highlight this sort of, nexus requirement, which they say that the persecution must be because of one of those protected grounds. And that might be something that is very obvious to your client. So if Taliban, come to their house and ransack it, to them, they might be like, well, this was clearly a threat because of my work for the US government, or they were looking for proof, of my work there or something like that. But the US really wants to see evidence of that connection. Like, were there threats? Did they say anything to your client that indicated, it was for this reason, and not sort of what the US classifies as like opportunistic violence, like, oh, they were just robbing your client for no reason in particular. So that's kind of like the sort of storytelling and evidence gathering that might be important for your client to have in mind, for just sort of how they're going to bring all those pieces together for their application. And then lastly, I just want to highlight that people have a 1-year deadline to file for asylum once they've entered the United States. However, parolees sort of get an extension for that. So it's generally about 6 months after their parole status expires to file for asylum. So here we have the 5 protected grounds: race, nationality, religion, political opinion, and particular social group. So the first 4 are pretty straightforward. I've put asterisks next to the ones that it's most likely an Afghan client would be arguing. So, for race, if someone is Hazara, that's, something to consider, as, perhaps they're being persecuted for that. For religion, even if someone is Muslim, they could argue that they're being persecuted because they're not practicing Islam the way that Taliban wants them to, or, they're not free to practice their particular sect, things like that. Political opinion, would also be opposing Taliban leadership, supporting the US government. Again, pretty straightforward. And this last one, particular social group, is this sort of like constantly evolving category that, again, you don't necessarily need to be prepared to know how to argue this for your client. But I just wanted to highlight it because if you have somebody that might not fit within one of these 4 categories, it's very possible that an attorney might be able to make a particular social group argument. And a particular social group is something that is defined by this, common, unchanging characteristic that is, very particular and specific and also socially visible, because someone needs to be able to persecute, somebody else based on how they understand that group membership. So I have some examples here of particular social groups that the US has found to be valid in the past. So you have family memberships, that could be like a family member of someone who worked for the US government, women refusing to conform to gender dress laws, sexual orientation, for domestic violence that was rampant in Guatemala. They were able to define married women in Guatemala unable to leave their relationship. And one of the other things too that's really important to understand about these 5 protected grounds is that a person does not need to actually belong to one of these groups. All that matters is that their persecutors perceive them to be part of that group. So there are certain things that, maybe your client actually doesn't have that political belief, or maybe, they don't necessarily want to identify with their sexual orientation to, social workers and other strangers they might not know. All that matters is that a persecutor has perceived them as that. So that's like another way that, you can remind your client that they can think about their asylum claim. So unfortunately, there are many bars to asylum as well. And I've highlighted these 5. Some of these bars also come into play for the temporary statuses and other statuses I talked about before. So, it's always important to look at the different requirements. But here, the first 2 and then the resettlement bar are the ones that Afghan clients tend to run into the most. So, the first 2, again, sort of plainly racist, but the US defines kind of terrorism and like engagement in persecution pretty expansively. So if a client has like evidence that they might have, either like worked with Taliban or a group that might have been engaging in persecution, or has even done things like pay for utilities to Taliban or pay a roadblock or some of these other things, they need to be prepared to talk about that in their asylum claim. And this doesn't necessarily mean that they will be fully prohibited, because, for example, you could argue that the persecutor bar doesn't apply to your client because they never directly engaged in those activities, were part of a completely different, division of the organization, and had no knowledge that they were occurring at that time. Or for the terrorism-related inadmissibility grounds, or TRIG, as they're called, there are particular exemptions that are recognized, such as, if somebody gave money to a terrorist organization under duress, like they were, stopped on their way trying to leave the country and had to pay a roadblock. And then there's also exemptions for people the US considers Afghan allies, or Afghan civil servants. And then this is just something that's also important to kind of raise with clients, because again, it might be very obvious to them, like, I was of course not supporting Taliban when I like had to pay them to leave the country. The US still might ask them like a lot of follow-up questions in their interview, even if it will ultimately be fine for your client. So it's just something to consider. And there's also crime bars. So either you're convicted in the US or you just committed a crime outside the US. You might not even need to be convicted. But political crimes don't count. So if someone was in prison for something you can classify as political, that won't be an issue. And then there's this kind of nebulous national security bar. Again, nobody really knows. But it can also pose trouble for your client. And then the last case is resettlement. This is especially important if your client spent a lot of time in a third country before coming to the United States. This tends to be like, Brazil or maybe Mexico, or Pakistan. And what's important here is to show that staying in that country long term wasn't an option. So either they were facing, additional threats, as many Afghans in Pakistan are, or they were not actually offered a permanent visa there. So, those are also things to be prepared to talk about. And because there are so many bars to asylum, this is why it's going to be very important to check the box that I'm going to talk about on the next slide. So on all applications for asylum, there's going to be this little line at the top. It's on the form I-589. It will say, do you want to apply for Convention Against Torture Relief and withholding as well? And so what this means is that if for some reason the asylum claim is denied, maybe for one of these bars or something, your client would automatically be considered for these two lesser forms of protection. And these forms of protection they kind of go back to that international law protection I was talking about, the principle of like non-refoulement, which means that, if someone shows that they are at risk of being tortured by the government, or that persecution is still pretty likely, even if it might not meet the standard of asylum, the US under international law cannot remove them to that country. So as you'll see here, these two forms of relief, they're very temporary. They cannot necessarily help you with like bringing your family or staying here long term, but somebody can work with this status and can be on the status while they pursue a more permanent pathway. And for these for CAT and withholding, if conditions in the country at any point change, such that to make it safe for your client, that person can be immediately removed. So that's just also something to consider, that if you get one of these, you should, begin looking for a permanent pathway. So with that, I will turn it over to Belinda for, the second half of the presentation.
Thanks, Steffi. So first of all, I wanted to acknowledge that we know it's a lot of information. I mean, immigration law is an incredibly complex, vast and constantly changing like set of rules and policies, and it feels impossible to keep up sometimes. So if you're sort of, drowning in information right now, we've all been there, especially us. And we don't expect anybody to become experts after this one presentation. And just to reassure you, all of these slides will be available after the webinar, plus the recording. We'll have them posted onto our website, ideally by the end of the week. So, if you want to print any of these beautiful charts that Steffi has put together as a reference, we encourage you to do that. And for any additional questions, you might have as you're going through cases or stories with your clients, you can always reach out to us for assistance. So for the Q&A as well at the end of the session, again, you're welcome to put your questions in the chat now. We'll just collect them there and then address them at the end. And also want to acknowledge that the rules are written in a way that makes them sound very scary, and they are something you should take very seriously, but for the most part, most rules and restrictions also have exceptions. So the best way to figure out if your client qualifies for an exception is to talk to an attorney, and when you identify one of those potential issues that Steffi has covered or that I will cover, that's usually a good sign that you need to reach out to an attorney. And on our end, as the attorneys on the receiving end of those requests, it's so helpful when a referral contains information about potential bars, because that means that we can give you much more relevant information, we can get you answers faster. So this is really a great opportunity for for you to help us help you. Okay, so I'm going to move into some of the nitty-gritty about the different forms of humanitarian relief that Steffi mentioned at the outset of this presentation. And we're going to start with the one that you're probably most familiar with, which is asylum. And asylum it's one form of protection, but there are two ways to get it. So first, we have affirmative asylum, and this refers to asylum that you are applying for from USCIS, which is an administrative agency. So when does someone qualify to apply affirmatively? Well, it's usually if you are in the United States with some kind of other permission or status. So basically, if the government is not trying to actively deport you, then you can apply affirmatively for asylum. So this also applies actually to individuals who do not have some kind of lawful status in the United States, or if they had a lawful status previously and it expired. As long as you're not in immigration court proceedings, you can apply affirmatively for asylum. Okay, so the second pathway or second way to get asylum is defensively. And you can only pursue asylum one of these ways at a time, by the way. It's not like a dual track. It's not like you can, submit one application in each, like in each context and see which one goes faster. They are mutually exclusive. So defensive asylum is a form of asylum or it's a way to apply for asylum as a defense to basically deportation. So the only reason the government would really initiate any kind of case against you in immigration court is if they're trying to deport you. There's not really anything else that an immigration court can do. The immigration courts are a special kind of court, very different from the kinds of courtrooms that you see on TV. That the standards of evidence are different, just the way things are done is different, and it's kind of like like In-N-Out. If you're looking at restaurants, they really only do one thing. So In-N-Out really just serves burgers, and immigration court really just serves deportations. It's not a great place to be, but it's not like a foregone conclusion that if you are placed in removal proceedings that you will be deported, because there are ways to defend against that. And one of the primary ways to defend against deportation is by claiming asylum as a defense to deportation. That's why we call it defensive asylum. Okay, so can we go up one? Yes. So just really quickly, there's a comparison table here that you can look at who reviews the application. We mentioned that if it's affirmative, it's USCIS, which is an administrative agency. You can refer back to the table at the beginning of the presentation for all the different government agencies that touch immigration applications. So USCIS is just an administrative agency. But if you are applying defensively, you have to apply directly with the immigration court. So you file your application with the court. You can do it in open court, which is the easiest way, but you could technically also file the application outside of a hearing just by physically going to the court, handing it to people at the window. You can also mail it in, but just know that it can get kind of complicated. So if you have someone who needs to apply for asylum defensively outside of a hearing, you should talk to an attorney. The timeline is the same. So affirmative and defensive applications must be filed within 1 year of entry into the United States, subject to certain limited exceptions. One of the most prominent exceptions that's applicable to newly arrived Afghans is that if someone has OAW parolee status, they get 2 years. And that's an exception. It's not a special rule for them. It's just a special exception that has been established for them. So affirmatively, there's not really an opposing party. It's not adversarial in the same way that a court proceeding is. So it's really just the asylum officer who's going to be asking questions at the interview. Whereas in a defensive asylum situation, there's an attorney, it's the government's attorney who is arguing against your client's case and trying to poke holes in it, basically trying to show that the client is not eligible for asylum protection. And then lastly, for appeal, for affirmative asylum applications, you technically can't appeal a denial of asylum, but you can reapply if you can show changed circumstances. And then on the defensive side, yes, you can appeal a denial of asylum, and that goes to a special appeals court called the Board of Immigration Appeals. Okay, thank you. So removal proceedings. I mentioned this just on the last slide, but the only reason a client would be in immigration court is if the government is trying to deport them. So they call it removal, sort of as a euphemism. Removal and deportation mean the same thing. And how do you know, though, if your client is in removal proceedings? Because just crossing the border does not immediately place someone in removal proceedings. It's not like Monopoly where you like pass go and then you collect $200, but in this case, instead of getting money, you get a notice to appear. That's not how that works. So, but you do need to check if someone has a notice to appear and is in immigration court proceedings, because if they're not in removal proceedings, then they can apply affirmatively, right, through USCIS. So the way that you can check is, first of all, if the client has received a document called a notice to appear, and there was, I think, an example of that document in one of the earlier slides, which you can go back and check later. That's how you know that the government is trying to initiate a case against the client. Another way is you can go onto the immigration court website, which will be linked later in the presentation, and you can type in the client's A number. And if there's a case pending against them in immigration court, it'll pull up a record that shows the client's name, the A number, the court that the case is pending in, the name of the judge, the date of the next hearing. So that's the best way to check. Okay. So in terms of the types of hearings, there are two types of hearings you can get. Well, there are a few different kinds, but the two that you should be aware of that you can get in immigration court are master calendar hearings and an individual calendar hearing. So master calendar hearings are just like preliminary hearings to handle small things like, do you have an attorney that you want to enter representation with, or, do you want to file an asylum application right now? Do you want, and then to take pleadings, for instance, like how are you going to respond to the charges that the government has laid against you? So master calendar hearings are sort of stops along the road to the final hearing, which we call the individual calendar hearing. Sometimes the individual hearing is also known as a merits hearing, because that's when the judge is going to hear and consider the merits of somebody's case. So the entire process can take, I think on average right now, a case in immigration court takes about 4.5 years. So it's quite a long time. But this is not standard across all cases. So some cases are expedited, like the government really, really is trying to remove you quickly. And in those cases, it can be months, between having a case initiated against you and then having a decision. But again, the decision is not a foregone conclusion. It's not guaranteed to be removal, guaranteed to be deportation. It could be a grant of asylum, right? That could be the decision. So it's important to note too that a person can apply for asylum at any point during their removal proceedings. So you don't have to apply during your first master calendar hearing. You don't have to apply during the second one. You won't have that many after that. But just so you know, as long as the court has not yet entered an order of removal against the client, they can submit an asylum application. Okay, next slide, please. Okay, so what should you do if you find out that your client is in removal proceedings? Well, you definitely want to refer them to an attorney. But I would say the first thing that you should do is check to see when their next hearing is. And then using the method that I just described and that we'll discuss a little later on, that'll tell you how urgent it is to get in touch with an attorney and what have you. Second thing is you need to figure out when they entered the United States, because again, we have that 1-year deadline. People have to apply for asylum within 1 year of entering the United States. And especially if we're talking about Afghans who entered through the southern border, chances are very high that they do not have OAW parole, because if they did, they wouldn't have to enter the country that way. And because they don't have OAW parole, they do not qualify for that exception, right? The exception that gives them 2 years to apply. So they have to make sure that they apply within, before the first anniversary of their entry into the United States. Okay, and the third thing after you've checked the next hearing date and checked the entry date, is make sure that the client knows they have to attend every single hearing. Even if the hearing happens to be in Los Angeles and they have moved to San Francisco, they have to attend. And that's because if you don't attend, the immigration judge can and will automatically order somebody to be deported. It's called removal in absentia. So if you don't show up, then they'll order you removed. So you should definitely always show up for your court date. So, but what if you have a case in a court that is hundreds of miles from where you live? Well, in that case, you would need to request the court to transfer your case to a more convenient location. And for that, you would need to contact an attorney. So you could reach out to us for that. Okay, but once the client is, in removal proceedings, again, they do have options, and the options include applying for asylum defensively, like we said, withholding of removal to prevent deportation to a country where they'll be tortured, or potentially they could adjust status to some kind of other immigration status. So maybe they entered the United States, without prior permission, through the southern border, but they happen to have a spouse who's a US citizen, technically you could apply for a green card based on that spousal relationship through the immigration court. And that's one way to obtain sort of relief from a removal order. And then lastly, there's something called voluntary departure. It's not something you really need to worry about. It has to do mostly with individuals who would have access to re-entering the United States, soon after being removed. But essentially, you're agreeing to leave the United States without the court actually issuing an order of removal against you. And the only reason you would do that, it's a strategic reason to preserve your access to immigration options in the future. Because if you're ordered deported from the United States after being here for a certain amount of time, you could be barred from obtaining any kind of lawful status in the future. Okay, next slide, please. All right, so where to access information? So I mentioned this a couple of slides ago. So one way you can look up a client's case to see if they have a case in immigration court is to go to this website, acis.eoir.justice.gov, and type in their A number. So once you type it in, if there's a case pending, again, you'll see a page that has all the information about the next hearing and also who the judge is. So that's a helpful tool. You could also call the hotline. This is the 1-800 number right here, and also type in the A number. The only downside with the hotline is you have to sit through seemingly endless pre-recorded messages before you can actually select options that will be useful to you. But I just used it yesterday, and so I can confirm that at least as of yesterday, it was still doing the things that we need it to do to give us the information that we're looking for. Okay, the client's notice to appear, that document also has information that is useful. So it'll have the A number and it might have court information. But it's important to note that this document gets generated usually like at the border, right? It's given to somebody who's being processed by Border Patrol or ICE or something. And it's not a document that's generated by the immigration court. So it still needs actually to be taken to the immigration court so that immigration court knows that ICE or DHS wants to open a case against someone. So sometimes a client might have a notice to appear, but there will be nothing in that online system about their case. And that's because immigration enforcement has not yet given a copy of this notice to appear to the court. It's confusing, we know. You ask us questions later if you encounter a client that has this piece of paper but does not have a case when you type the A number into the system. Okay. Unfortunately, there are also a lot of Afghans who are detained after crossing the border. And we see people detained just for all kinds of reasons. It's not just, young men who, who the government thinks may have, worked in the military or something like that. We've seen elderly women being detained, like, young, young women, people who are sick, with chronic illnesses, like all kinds of people are getting detained, often, without rhyme or reason, and it can be a very distressing situation for both the detainees and their loved ones. And we at Project ANAR are working now to try to get another project off the ground that specifically assists individuals who are detained, trying to get them out of detention so that they can at least, be, with family or with community while their immigration cases are pending. So if you have clients who were separated from family members when they entered and they don't know where those family members have been taken, you can log on to this ICE detainee locator that you see on the slide here and type in the A number. A problem is, though, that you do need the A number of that family member, and it will tell you where someone has been detained. So it's not unusual for a family to enter through the southern border, like at, near like San Diego, and then for one of the family members to be moved to a detention center in Louisiana. That happens a lot, actually, Louisiana specifically. Yeah. So again, if you encounter anybody who has a family member who's detained, please feel free to reach out to us either via email, or you can leave us a message with the information that's listed here, and we'll see what we can do to work with you to try to get that individual released. Okay. In our pre-webinar poll, the majority of you who responded, thank you for your responses, by the way, the majority of you who responded indicated that you really wanted to learn more about family reunification. So I wish that this were an easier, kind of process, but this is basically, who is eligible to make some kind of request to bring family members over, and also shows you the basis under which people can make those requests. So broadly speaking, people who have some kind of permanent status can bring derivatives or can sponsor family members. So permanent status includes green cards and citizenship. There we go. And technically, asylum is an indefinite status. So we mentioned before that asylees they may apply for a green card after 1 year, but if they don't apply for the green card, it's not like their asylum expires. Asylum is an indefinite status. The only thing that would, terminate the status is if the circumstances that underpin the asylum claim are no longer, no longer exist. So, for instance, if someone is fleeing like political persecution and then there's a regime change and people are no longer being persecuted on that basis. That's one example. It doesn't happen very often, but that's the only, it's a very narrow set of circumstances under which asylum would terminate. But anyway, so temporary statuses, though, people under temporary statuses generally cannot sponsor family to come. Okay, so family, the US government's definition of family, at least the family that matters for immigration purposes, is again very narrow, and it depends on also what kind of status you have. So US citizens have the greatest amount of family sponsoring power. So US citizens are the only group of people who can sponsor siblings for green cards, for instance. But it takes a really long time, unfortunately, for the siblings of US citizens to actually receive green cards to come to the US. So there's a little table here that you can refer to later. But suffice it to say that US citizens have the most power, and then I would say, green card holders have the next greatest power. And then somewhere up around green card holders, you also have folks who have been granted asylum. So actually, once someone has been granted asylum, they can bring spouse or children. But it's important to note that their derivatives cannot bring derivatives. So the child, if the child is 19 or 20 and also has their own child, that grandchild cannot be brought as a derivative, but you might be able to get the grandchild in with humanitarian parole or something else, but that's a question for an attorney. Okay, next slide. Okay, so for a very specific set of people, for Afghans who were brought to the United States during the evacuation during Operation Allies Welcome, those parolees can apply to be reunified with their spouses and their children, or if the parolee is a child, they can be reunified with their primary caregiver through this process, through this, by using this form, DS 4317. This is a State Department form, and the agency at the State Department that's tasked with reunifying families that were separated during the evacuation. It's called CARE, C-A-R-E, which I think we may have referenced a little earlier. And this is the form that you use. So if you have a client who entered the United States during the evacuation, right, and they were separated at the airport or what have you from a spouse or from their children, or if it's a child who's here alone and was separated from their family, you can use this form to be reunified with those family members. So those family members, interestingly, when they are brought to the United States, they come with refugee status. So they don't have to apply for asylum or anything else. They already have refugee status. And as we noted before, they have to apply for a green card within 1 year. Okay. Yes, and then if you are a parolee and you subsequently get TPS, you're still eligible to use this form. Okay, next, please. So the government has sort of an unofficial policy about who is eligible to get on a US government funded relocation flight. This is a resource that we'll also put online with the presentation later. And you can see, some are clear yeses, some are nos, some are maybes. And feel free to sort of review this on your own time. And if you have questions about it, you can let us know. What's on here that we want to call out? Yeah, we can answer questions about that later if you would like. So we'll move on. Thank you. Okay, so for public benefits, note that most non-citizens are not eligible to receive public benefits, but Afghan parolees are actually able to access a pretty robust set of benefits. And importantly, when they apply later on for some kind of permanent status, like for a green card through asylum or whatever else, they don't have to worry about the fact that they previously accepted public benefits. So why would this be a concern even? Well, when someone is trying to apply for a green card, adjusting from a temporary status to a permanent one, there is a test. There are several tests actually that someone needs to pass in order to be granted the green card. One of them is called public charge. And the idea is that if you have received certain types of public benefits in the last, 5 or 10 years, something like that, you would not be eligible to get a green card. And that's because the US government doesn't want to allow people to immigrate to the United States if those people are going to become dependent on government benefits. It's essentially a wealth test for immigrants. And it's something that causes people a lot of stress, but the good news, I guess, is that for asylees, the public charge rule doesn't apply, and also for OAW parolees who are receiving benefits under the OAW parole, those benefits won't be counted against you. Okay. So the other types of relief you can get in immigration court also what could make you eligible for certain public benefits. So there's information here on like withholding of removal. And so if you have a client in that situation, feel free to refer to this slide, or if you can't get an answer by looking at the slides, then feel free to reach out to an attorney. Okay, so we mentioned before that if someone arrives through the southern border, they probably are not eligible for the benefits that OAW parolees are eligible for, because OAW, it refers to the evacuation mission, right? When people were brought over or came on US evacuation flights. But it's sometimes we see people get released from like ICE custody with a special code that makes them eligible for parole, or for parole benefits, excuse me. It can be confusing. It's hard to know when this has happened. So if you have, a client who has like a document that says they have conditional parole, or like 1-year parole, something like that, you should definitely reach out to us or other attorneys, so we can see if they have that special parole code that would make them eligible for OAW parolee benefits. And most importantly, maybe it also makes them eligible to apply for a work permit. Okay, so this is a document that is probably familiar to a lot of you. This is the employment authorization document. Applying for an employment authorization document can be very expensive, but thankfully for most of you, for most Afghan applicants, the different grounds or bases under which they would be applying for a work permit include fee waivers. So you don't really have to worry about paying this fee, at least the first time that you're applying for the permit. You might need to pay the renewal fee. And these work permits also have a lot of really useful information on them. So if you're meeting a client for the first time and you don't know what their status is, and they don't know what their status is, but they have a work permit, you can actually tell what status they have by looking under category, right in the middle, right there. So there's a code there. And that code, if you look it up, will tell you, what category someone is under. So parole status, like OAW parole, is code C11. And I think pending asylum is code C08. I think it's 08 or 09. It's one of those. But this is how you can tell the basis under which the work permit was issued. And work permits are not standalone benefits. You can't only apply for a work permit. It has to be attached to some other kind of application for relief. It has to have a category, like we just mentioned. Okay, move on, please. Great. So some high-level reminders for your clients. First of all, if they move, they must notify EOIR, EOIR, that's basically it's the immigration courts. You have to notify them within 10 days. Second, ICE and also USCIS can and will look at all of a client's social media activity. So be careful on social media. So for instance, we've heard reports of asylum applicants being called into the asylum office for second interviews or third interviews because there's a special unit in the asylum office that is tasked with basically digging through people's social media accounts. And so if your client has liked, like a controversial figures post or something like that, it will probably come up in your asylum interview. So it's just something to be aware of. Okay, fee waivers and exemptions. Thankfully, there are a lot of fee waivers and exemptions that are available for Afghans for different categories of applications. You may have heard that there was a waiver of the application fee for the I-130. That's the petition for alien relative that you use to initiate a green card application for a family member. You may have heard that there was like a deadline, like September 30th. You have to get your applications in before September 30th to qualify for the exemption, for the fee waiver. And that was true. And then thankfully, a few days before that deadline, the government announced that they were going to extend the waiver. So the fees are still waived for I-130s, but only for those categories of family members who don't have to wait for a visa. So that includes, at this point, really only the parents and the unmarried children under the age of 21 of US citizens. Okay, so next, if they received an NTA but don't have a court date, you should keep checking the website or call the phone number for the immigration court to check for a court date. You can also, you can call the court, but there's not really anything they can do, because if there's no record of your client in the system, there's nothing for them to look at, unfortunately. Okay, another issue that you might encounter when you are meeting with a new client for the first time is they might not know if an asylum application has actually been filed for them. Because a lot of people, go to different, maybe different service providers who may have helped with different portions of the application, but the client never received confirmation that the application was filed. So how can you tell if an application was actually filed with the immigration court? The most reliable way is really to call the immigration court and give them the A number and ask. But if it's urgent, you need to figure it out and the immigration court is closed or you can't get through for some reason, you can also call the hotline that we mentioned and sit through all the automated messaging, and then select the option for checking the clock, how much time has accrued on the asylum clock. So the asylum clock refers to the number of days that have elapsed since the filing of an asylum application. And the reason that they're counting days is because asylum applicants are eligible to apply for work authorization after their application has been pending for at least 150 days. Technically, they can't receive the work permit until it's been pending for 180 days, which is 6 months, but you can submit an application 30 days before that. So that's 150 days. So if there's an asylum clock, if there are days that have elapsed since the filing of the application, that means an application was filed. But if there are 0 days on the clock, that means almost always it means that no application has been filed. So that's one way to tell. Okay, finally, we made it to, that's really the end of the presentation for now. I'm sure you have lots of questions, but in the meantime, we have compiled a list of resources here that you can refer to, other legal services providers that can provide technical assistance and perhaps even take on cases for your clients. And then also we have our own contact information here if you would like more information. Some of the organizations that are listed on the slide, we might have folks from those orgs on this call, and if so, welcome. Thank you for doing what you do and for working with us to serve newly arrived Afghans. And I think that's the end. Yep. So our contact information, or at least emails for myself and for Steffi, are on this slide here. Feel free to email us whenever you would like. We do apologize. It can take us a little while to get back to you on requests, just depending on the volume of requests we've received recently. We are a very small team. There are 5 of us full time. So, but we do, try to get back to everybody in a timely manner. And if you have a really urgent, like a true emergency, please, feel free to flag that for us in the subject line, and we'll be sure to try to get to that as soon as we can. Okay, and with that, I think we're going to go ahead and stop the recording so we can move into Q&A.